Thanks for tuning in. My name is David Fraser, and I'm a privacy lawyer with the Canadian law firm Megan Cooper. I spend a lot of time watching videos on YouTube, and given my interest in law, photography, videography, and drones, my recommendations sometimes include videos of what are often called freedom of expression auditors, or in the US, First Amendment auditors. You may not be familiar with this type of activity, so let me describe it. Essentially, the practice is ostensibly done by people to determine whether their rights to photograph or video record in public places will be respected. First Amendment audits involve people filming in public places, often in government buildings, to test their right to record in public. So if no confrontation or attempt to stop the filming occurs, then the facility passes the audit. If an employee or a police officer attempts to stop them filming the event, it fails the audit. Now, what actually prompted me to make this video right now was a conversation I had this week with a person who has spent an entire career in policing and training the police. He'd seen my videos on recording the police, taking photographs and videos in public, and also my video on photography bans. He's trying to get more and better training for the police in Canada on the topic of auditors and so-called cop watchers and the laws around their activities. Auditors believe that what they do promotes government transparency, but critics find it confrontational and potentially harassing. While I think this originated in the US, this practice has spread to other countries, including Canada. Auditors often film in public spaces, like sidewalks or post offices, and it will often lead to conflicts with property owners who try to restrict the photography. Now, the police may be called, and auditors sometimes face arrest for various charges. Now, usually if a confrontation ensues and the situation escalates. Now, the practice will involve the individual filming their entire encounter with staff and the customers at the public facility, including any escalation, including any argument, including any confrontation. Now, a lot of people don't like to be recorded, even in a public place, and they get upset about it. And also, a lot of people, the police included, often don't know the law around recording people and places in public. Some auditors even use drones in addition to regular recording equipment, and the law related to this is even less well known to the public and to the police. So I'm going to talk about the law in Canada, where auditing seems to be a growing phenomenon. I should also note that I'm not a fan of aggressive auditors who really do appear to be looking for a confrontation, likely for the attention, for the clicks, for the views. Now, one of my favorite auditors is a fellow in the UK called DJ Audits. He seems to be a really affable fellow who goes through industrial estates, or as we call them, business parks, and records what he finds interesting from public areas. He flies his drone over the property to get a bird's eye view of areas that are not readily viewable from eye level. He's never really confrontational. He knows his rights and really seems eager to educate people on his right to record on the ground and from the air. He's often confronted by people. He's been arrested and has successfully sued the police for wrongful arrest. And it's remarkable the number of people he encounters on the regular, particularly security guards, who have no idea what the law is in this area. They just assume it's illegal. They assume it's prohibited. Now, it's clear to me that the police in the UK have been much better trained about the law around auditors, and there are loads of American resources out there for police training on how to interact with auditors. I'm confident that the police in Canada currently have little training about this at all. Now, before I get into the substance, I'll also emphasize that this is intended to be educational and not legal advice. If you're an auditor or a cop watcher in Canada, you really should have your own lawyer, and they should give you specific advice about your specific activities. Now, people have been shot in the US for doing this, and an aggressive interaction with an armed police officer is inherently a volatile situation. I'll also note that I don't practice criminal defense law, so if you get into trouble, you'll have to find a defense lawyer. In a nutshell, in Canada, you have the right to take photos and record video in a public place. There's nothing in Canadian criminal law that makes it illegal to take photos or videos in a public place. This right extends to photographing or recording anything visible from a public place, including private property, as long as you are not trespassing. The right is protected under Section 2B of the Canadian Charter of Rights and Freedoms, which guarantees freedom of expression. This includes the right to collect information through photography and videography. And photography and videography are inherently expressive activities. Now, however, this right is not absolute. Now, general laws are always going to apply. You can't create a nuisance, you can't damage property, you can't obstruct traffic, or actually interfere with legitimate police duties. So what laws can come into play? The first is trespassing, which is generally a civil matter. You can't go onto private property except by invitation, and that invitation can be expressed or it can be implied. A store or a shopping center is private property, but there's an implied invitation to the public to enter the premises to shop there and do normal, expected things. A property owner can put conditions on your entry, like no shirt, no shoes, no service. And they can also put a no photography condition. And if you violate a reasonable rule that was a condition of your going onto the property, was a condition of your invitation, you would be trespassing. Now, that's not a criminal offense, but it can veer into causing a nuisance or disturbance. Now, what we often think of as public buildings are a different matter. Private property owners are not subject to the charter, so the rules that they can implement are largely discretionary. Governments and government agencies are subject to the charter, and rules that they make, which affect expressive activity, like photography and videography, are subject to charter scrutiny. I don't think there could be any doubt that the charter applies to municipalities, provinces, and the federal government. It even applies to school boards and universities. There are loads of cases where individuals and businesses have challenged bylaws and municipal policies for allegedly violating the charter. In a ban on photography or videography in or near a government building, prima facie violates Section 2B of the Charter of Rights and Freedoms. That section reads, under the heading Fundamental Freedoms, everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, we're focused on freedom of expression, and note that includes freedom of the press, but freedom of expression is a right enjoyed by everyone, not just the press. So this question about banning or regulating photography or videography in certain places, this question's been before the courts before. There's actually a series of decisions from Ontario in the late 80s and early 90s called Squires, in which provisions of the Ontario Courts of Justice Act that prohibited photography and videography in and around courthouses was challenged. Now, not surprisingly, it was challenged by the media, but remember that charter right applies to everyone. In that case, the majority of the Ontario Court of Appeal held, quote, the freedom of expression enjoyed by television journalists, such as the appellant, is the freedom to film events as they occur and to broadcast the film to the public. If television journalists are unable to photograph persons entering or leaving a courtroom, their freedom of expression is curtailed. I agree, therefore, with Justice Taryn-Polsky that Section 67 sub 2 sub A sub 2 of the Ontario Courts of Justice Act infringes the freedom of expression conferred on the appellant by Section 2B of the Charter. So here you have the highest court in Ontario saying that it violates Section 2B of the Charter for a law to say where someone can and can't film. But as I'll discuss, this right is not absolute, and it can be subject to reasonable limitations. There's an interesting decision from 1989 where anti-sealing activists challenged a federal regulation. And that regulation prohibited people from being within a certain distance of seal harvesting that was being done. Now, the anti-sealing activists wanted to film and photograph the harvesting of seals, and they wanted to get the media out there to spread their message. But the half a nautical mile restriction prevented them from doing so. The Federal Court of Canada and then the Federal Court of Appeal determined that this access restriction violated their charter-protected freedom of expression. Even though the regulation said nothing about expression, it just had the effect of curtailing this freedom of expression by preventing anybody who is not engaged in sealing from being within that radius of where that activity was happening. Now, I should note that assaulting someone with your phone is not charter-protected, but filming them with it is charter-protected. But putting your phone aggressively in someone's face is likely an assault. Now, as I mentioned, the Charter Section 2B can be subject to reasonable limitations. And in order for an infringement of your Section 2B rights to be justified, the framework is under Section 1 of the Charter, applying something called the Oakes test. In order to pass the Oakes test, a restriction has to be prescribed by law, it has to have a pressing and substantial objective, the means chosen by the government actor must be rationally connected to that pressing and substantial objective. 4, it has to impair the affected charter right as little as possible. And 5, there's an ultimate balancing of the positive effects of the government action versus the negative impact on the charter right. And that has to weigh in favor of the government. If the government action fails any of those 5 things, it fails to survive the Section 1 analysis. It is of no force and effect. Now, a policy of no photography in a public hospital waiting room is likely a reasonable limitation in light of the legitimate privacy interests of the other people there. A ban on photography at a sensitive military installation can likely be justified, provided there's a real risk to the security of the property. Now, no recording in a courtroom has been justified, but as we saw a moment ago, a ban on recording in the hallways of a courthouse was not justified. Now, all of these have to be determined on a case-by-case basis, but as I discussed in a previous video on photography bans, the blanket bans on photography imposed by the North Bay Police and the Peterborough Police in Ontario, that likely can't be justified. A categorical ban on photography in the publicly accessible areas of police stations may not meet the minimal impairment and overall balancing requirements. It would, in my view, prevent the reporting of newsworthy events and undermine police accountability. I should also note that if someone just puts up a sign that says no photography, no videography, it does not affect anyone who is in a truly public place. The terms of the sign could be enforced against somebody going onto the private property that is subject to those conditions, but slapping a no photography sign on a perimeter fence does not affect or have any power over someone on the outside. You may ask, well, what about privacy laws? You're talking about recording people in public places. Now, the ones I deal with most often regulate what businesses can do. An individual taking photos for personal purposes is not a business. And just to be clear, they also have carve-outs for personal use and artistic use. Here's what PIPEDA says. This part 1 of PIPEDA, does not apply to any individual in respect of personal information that the individual collects, uses, or discloses for personal or domestic purposes, and does not collect, use, or disclose for any other purpose. Or any organization in respect of personal information that the organization collects, uses, or discloses for journalistic, artistic, or literary purposes, and does not collect, use, or disclose for any other purpose. The other provincial general privacy laws have similar exclusions. Now, I could imagine a privacy commissioner saying that a YouTube auditor who makes a living from monetized videos is engaged in commercial activity, so these exceptions don't apply, or they're collecting, using, or disclosing personal information for additional purposes. And my response to that would be that such an interpretation of their privacy laws would be unconstitutional as a violation of Section 2B of the Charter-related right to freedom of expression. The Alberta Privacy Statute was actually found to be unconstitutional because it effectively prohibited union members from recording in a public place, a picket line. Now, what about the privacy torts? What about the risk of being sued for damages for invasion of privacy? In most situations, I don't think that's likely either. In most common law provinces, you can sue or be sued for something called intrusion upon seclusion. And it is, in summary, an intentional or reckless intrusion without lawful justification into the plaintiff's private affairs or concerns that would be highly offensive to a reasonable person. So if you poke into someone's private life in a way that would be highly offensive, harm and damages are presumed. You can also be sued for public disclosure of private facts, which also has to engage someone's private life and be truly offensive to a reasonable person. And it's hard to see how taking photographs or video in a public place would engage someone's private and intimate life, and also be highly offensive to a reasonable person. Now, it could be engaged if you were stalking or harassing or surveilling someone, though. We also have statutory torts related to the invasion of privacy. Some provinces have these. So here's the gist from the British Columbia Privacy Act. It says it is a tort actionable without proof of damage for a person willfully and without a claim of right to violate the privacy of another. Note the violation has to be without a claim of right or a legitimate justification. It then goes on and says, the nature and degree of privacy to which a person is entitled in a situation or in relation to a matter is that which is reasonable in the circumstances, giving due regard to the lawful interests of others. And then in determining whether the act or conduct of a person is a violation of another's privacy, regard must be given to the nature, incidence, and occasion of the act or conduct, or to any domestic or other relationship between the parties. Now note, it specifically refers to eavesdropping and surveillance in subsection 4, which reads, without limiting subsections 1 to 3, privacy may be violated by eavesdropping or surveillance, whether or not accomplished by trespass. Again, it's hard to see how obviously taking photographs or video in a public place would engage this tort, but it could be engaged if one were stalking someone or engaged in repetitive surveillance. But don't record into people's windows, which brings us to the crime of voyeurism, which has a few nuances and can apply in public or quasi-public places. It was added to the criminal code relatively recently. Now, voyeurism involves surreptitiously observing or recording a person where there is a reasonable expectation of privacy. It has to be surreptitious, and there has to be a reasonable expectation of privacy. Paragraph 1 makes it an offense to observe or record in a place in which a person can reasonably be expected to be nude or to be engaged in explicit sexual activity. Maybe like a change room, a bedroom, a bathroom. Paragraph B makes it an offense where the recording or observing is done for the purpose of observing or recording a person in such a state or engage in such an activity, regardless of where that is. And paragraph C covers a broader range of observation or recording, but where it's done for a sexual purpose. Now, people should be aware that the courts have held you can have a reasonable expectation of privacy in a reasonably public place, and that the expectation of privacy can vary according to the method of observation. So, for example, you may not have much of an expectation of privacy with regard to being observed by someone at eye level in a public place. But you may have an expectation of privacy from being observed or recorded, for example, up a person's dress or looking down somebody's top. I haven't seen many auditing videos where one could reasonably allege legal voyeurism, but the term does come up from time to time in its more traditional usage. Another law that could be engaged is the common law tort of nuisance and the more serious criminal offense of mischief. A nuisance is interfering with someone's enjoyment of their property. The interference has to be substantial, and I think it would have to be pretty outrageous, or it'd have to be regularly repeated. Now, I can imagine a scenario in which someone has a backyard pool with a privacy fence around it, and if someone hovered a drone over the pool while people were sunning themselves, the presence of the drone could really interfere with the usual and expected enjoyment of the pool. Hanging around a public pool, recording everyone there will likely be seen as interfering with people's enjoyment of the pool. Now, I've never seen a case that addresses that, but if you're in a public place, not actively interfering with someone else's use of the space, it would be hard to call that a true nuisance. Now, it should also be noted that serious interference with someone's lawful enjoyment of their property could also be the criminal code offense of mischief. Now, I think it would have to be pretty serious, and I can't find any cases that have considered public photography as causing such mischief. However, if an auditor were particularly confrontational, I would not be surprised to see the police interpret that as mischief and make an arrest. So what about recording the police from a public or a quasi-public place, or even from within your own property? So let's talk about recording the police in public. In short, there's no law in Canada that prevents a member of the public from taking photographs or video of a police officer executing their duties in public or in a location lawfully controlled by the photographer. Now, I have a full video on the topic that I'll link to below. Now, as we've discussed, people in public places, or people in places that are generally accessible to the public, or people in places that are within public view, they have a reduced expectation of privacy. So you take that and then add on top of that the police, who are public servants working in the course of their employment, they would have a further reduced expectation of privacy, and they would also have a greater expectation of accountability to the police. This is particularly the case with police officers compared to other civil servants, where they're given extraordinary powers, they're given guns, and they're sent out into the streets. There is the critical component, which is their accountability to the public. And if their actions cannot withstand public scrutiny, that's important for the public to know. And yes, you can and you do have a charter-protected right to film and photograph the police in public, but you cannot interfere with or obstruct the lawful actions of a peace officer. So if a police officer is carrying out their lawful duty, and it has to be a lawful duty, and you interfere with that or you obstruct that, you could be charged with and be found guilty of obstruction. But in the vast majority of cases, someone standing on the sidelines with a camera phone, not in the way, would not be obstructing. And they would have a lawful right, a charter-protected right, to record a police officer doing whatever they are doing in public or in view of the public. A good case study is an Ontario Court of Justice decision from 2013 called R and Zarafinitis. In that case, an Ontario Court of Justice hearing was held in order to determine the appropriate sentencing for a police officer who had pled guilty of assault causing bodily harm. He assaulted a photographer. The defendant police officer attended at a bar in response to several noise complaints. Now, at the time, there happened to be a professional photographer in the bar who had been hired to take pictures of a rap competition. And so, of course, the police officer comes in, and you have a professional photographer with the camera. The camera turns around, and he starts taking photographs of the police interacting with individuals in the bar. And when the police ejected people from the bar, the photographer followed along and continued to take photographs out in the street of the interactions between the police and others with whom the police officers were interacting. Now, at that point, the cop ordered the photographer to stop taking photos and then told the photographer to leave the area. The photographer, rightfully, refused, and the police officer arrested the photographer for public intoxication, which is a regulatory offense under Ontario's liquor control regulations. And in the course of arresting the photographer, the cop punched the photographer while subduing him, breaking bones in his face. So we have a significant assault or a significant use of force in making that arrest. And the officer was charged with assault causing bodily harm, which was deemed to be excessive. So the question was, what sentence was going to be appropriate for this police officer? And so in determining the appropriateness of the sentence, the court went through what happened and what were the different interests at play in the interaction. Okay, so this is from the decision starting at paragraph 24. Here the court says, in the course of submissions, I asked Mr. McKay whether or not the direction to stop photographing was a lawful direction. I eventually got an answer that I take to be the only sound answer to the question. Unless Mr. Farkas's presence or actions were creating a danger to him or others, ordering him to stop photographing was not a lawful command on Mr. Zerafinitis' part. This is not a trivial matter. Well, indeed. So unless the photographer's presence or actions were creating a danger to himself or to others, ordering him to stop photographing was not a lawful command on the cop's part. The court then goes on to talk about the interaction between the police and the public, and particularly the right of the public to take photographs in circumstances like this. The court notes this is applicable across the board. I'm going to read all of paragraph 26 of the decision because it really hits the nail on the head. The court says police-citizen interaction typically involves a significant power imbalance. Just as judges should be hesitant to second-guess police decisions often made under stress, without time for long reflection in back alleys late at night, we have to recognize that the citizen on the other side of that interaction, who may or may not have committed an offense, and who is entitled to the protection of the rule of law, is also often alone in a back alley late at night. The court then says, in the absence of an overarching and tangible safety concern, such as telling a photographer at a fire scene to back away if there's a danger that the building will collapse on him, telling people not to record these interactions, whether they be a bystander or the person the police are dealing with, is not a lawful exercise of police power. An officer who conducts himself reasonably has nothing to fear from an audio, video, or photographic record of his interaction with the police. The public has a right to use means at their disposal to record their interactions with the police, something that many police services themselves do through in-car cameras and similar technology. The officer's powers exist to allow him to protect the public and himself and to enforce the law. They do not extend to controlling the public record of what happened. The maintenance of that public record plays a significant role in the maintenance of the rule of law. The existence of this form of objective oversight has great potential to minimize abuses of authority and to maintain peaceable interaction between police and the citizenry, all of which is very much in the public interest. Interference by a police officer in the public's exercise of that right is a significant abuse of authority. So let me underline that, a significant abuse of an authority. And just as an aside here, I've had conversations with police officers who have said to me that frankly their actions in public and in private should be able to withstand public scrutiny by recording. So preventing someone from recording police actions can be seen as an infringement of their charter rights and an abuse of authority. However, you can't interfere with a police officer's lawful exercise of their duties, but simply standing on the sidelines and taking photos or videos does not typically constitute interference or obstruction. If you're commanded to stop taking photos, that's likely an unlawful command that you do not have to follow, provided you are not interfering with the police. Police cannot force you to unlock your phone or delete photos without a warrant, unless the phone contains evidence of a crime or is seized incident to the arrest. So what's the conclusion here? The issue of auditing public spaces to test the right to record, it's a complex one, balancing freedom of expression with privacy concerns and the lawful duties of authorities. In Canada, the right to take photos and videos in public is constitutionally protected, but it's not absolute. It is subject to limitations such as trespassing laws, criminal laws like voyeurism, nuisance laws, the need to actually avoid interfering with active police legitimate duties. Now, while recording police in public is generally permissible and even encouraged as a form of public accountability, obstructing the police in the course of their duties is not. It's crucial to remember that the law in this area is very fact-specific. And while I hope I've provided an educational kind of general overview, this shouldn't be treated as legal advice. Anyone who's involved in these activities should consult with a legal professional to ensure that they are acting within the bounds of the law and that they know how to assert their rights without escalating the situation, which could cause a pretty unpleasant outcome. So if you've made it to the end here, you're likely someone who should subscribe to this channel. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. There's a bell to get notified of new episodes. Also, you can leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian privacy law. Thanks for tuning in.